Good evening, friends. Let us solve question number 6, paper 1, Advocate on Record, year 2019. Question is it open to the High Court to entertain a review petition seeking review of its order when the SLP filed against the said order has been dismissed by the Supreme Court? Second part is, does it make a difference if the review petition was filed before the dismissal of SLP? This is the question. Let us, friends, dive into the answer. We have to go through doctrine of merger to give answer to both the questions. The doctrine of merger and right of review are concepts which are closely interlinked. If the judgment of the High Court has come up to Supreme Court by way of special leave, and special leave is granted, and the appeal is disposed of with or without reasons by affirmance or otherwise, the judgment of the High Court merges with that of Supreme Court. In that event, it is not permissible to move the High Court by review because the judgment of the High Court has merged with the judgment of Supreme Court. But when where the special leave petition is dismissed, there being no merger, the aggrieved party is not deprived of any statutory right of review if it was available and he can pursue it. It may be that the review court may interfere or it may not interfere, depending upon the law and principles applicable to interference in the review. But the High Court, if it exercises a power of review or deals with the review application on merits, in a case where the High Court's order had not merged with an order passed by Supreme Court after the grant of special leave, the High Court could not in law be said to be wrong in exercising statutory jurisdiction or power vested in it. Now, second situation, we assume the review is filed first and delay in the SLP is condoned and special leave petition is ultimately granted and the appeal is pending in Supreme Court. The position then under Order 47, Rule 1 CP is that still the review can be disposed of by the High Court. If the review of decree is granted before the disposal of appeal against the decree appealed against will cease to exist and appeal will be rendered incompetent. An appeal cannot be preferred against a decree after review against the decree has been granted. This is because the decree reviewed gets merged in the decree passed on review and the appeal to the superior court preferred against the earlier decree, the one before review, becomes infructuous. The review can be filed even after SLP is dismissed, is clear from the language of the Order 47, Rule 1A. No appeal has been preferred in the Order 47, Rule 1 would also mean a situation where special leave is not granted. Till then, there is no appeal in the eyes of law before the Supreme Court. Therefore, review can be preferred in the High Court before special leave is granted, but not after it is granted. The reason is obvious. Once a special leave is granted, the jurisdiction to consider the validity of the High Court's order vests in the Supreme Court, and the High Court cannot entertain a review thereafter, unless such a review application was preferred in the High Court before special leave was granted. Thus, in view of the above law, review petition is maintainable before the High Court, even if the SLP has been dismissed before the Supreme Court. That's all. I have, friends, given answer to both the parts. Read it again, listen again. You will 100% understand what I want.